So, take two. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels, and yes, we're getting back into our HIPAA series. But first, brief disclaimer. When we are doing this series for HIPAA or any of our other series, you'll always find the links to all source information right there in the description box. So, should you like to do a deep dive on your own or would like to have a civil debate in the comments on the facts, you should certainly be able to do so. Trigger warning, this channel is marked not for kids for a reason. I do use profanity, and some of the topics we cover on this channel are pretty dark. So if you got a child that is 16 and younger and they are watching this, parental supervision is advised. Political warning, if you are left or right, I don't care and I am neither. I vote very specifically on where politicians stand on disability policy. So I'm not even affiliated with the independent party. I'm just legit out here on my own. So I may say something in one of these series that may offend you. If you can't handle that without name calling, your comment will be deleted and you will be blocked. Nobody has time for this type of childishness, especially not right now. All right? Cool. All right. Now, let's get back to where we were. So this one says FDA regulation regarding FDA regulated products or activities for purposes such as adverse event reporting, tracking of products, product recalls, and post-marketing surveillance. Individuals who may have contacted or been exposed to a communicable disease when notification is authorized by law, and employers regarding employees when requested by employers for information concerning a work-related illness or injury or workplace-related medical surveillance because such information is needed by the employer to comply with the Occupational Safety and Health Administration (OSHA) for the Mine Safety and Health Administration. See additional guidance, you can always see that there, public health activities and how that may affect your HIPAA protection. Now let's go ahead and move forward here. So victims of abuse, neglect, or domestic violence. In certain circumstances, covered entities may disclose protected health information to appropriate government authorities regarding victims of abuse, neglect, or domestic violence. What we call that in the healthcare circles, folks, is called mandated reporter. If we suspect abuse, it is our obligation under the law to report those said suspicions to a higher up, somebody who's in charge, whether we want to or not. It's mandated and mandatory. So that is the sort of thing there. Even if the individual who comes in says nothing about it or asks you not to, the obligation is, if it looks like somebody may be under threat, you have to do it anyways. So that's what that has to do with there, in particular when it comes to medical professionals. The patient's safety comes even above their own wishes sometimes when you're dealing with circumstances like that in particular. All right, health oversight activities. Covered entities may disclose protected health information to health oversight agencies as defined in the rule for purposes of legally authorized health oversight activities, such as audits and investigations necessary for oversight of the healthcare system and government benefit programs. This kind of really doesn't directly affect us in any real way, at least not at the same level that RFK, the water make frogs gay junior, freaking Kennedy. Good God. I don't know what went wrong with that boy, but my only thing I can think of is a lot. Judicial and administrative proceedings. Covered entities may disclose protected health information in a judicial or administrative proceeding if the request for information is through an order from a court or administrative tribunal. So one of those circumstances again. Such information may also be disclosed in response to a subpoena or other lawful process if certain assurances regarding notice to the individual or a protective order are provided. So for court cases, it may be mandatory to put aside the HIPAA protections whether we like it or not. That's why I also recommend durable power of attorney for those types of situations, which we'll be getting more into on Sunday, so stay tuned, folks. Law enforcement purposes. Covered entities may disclose protected health information to law enforcement officials for law enforcement purposes under the following 6 circumstances and subject to specified conditions. As required by law, including court orders, court ordered warrants, subpoenas, and administrative requests to identify or locate a suspect, fugitive, material witness, or missing person. In response to a law enforcement official's request for information about a victim or suspected victim of a crime, to alert law enforcement of a person's death if the covered entity suspects that criminal activity caused the death, when a covered entity believes that protected health information is evidence of a crime that occurred on its premises, and by a covered healthcare provider in a medical emergency not occurring on its premises, when necessary to inform law enforcement about the commission and nature of the crime, the location of the crime or victims, and the perpetrator of the crime. Descendants. Covered entities may disclose protected health information to funeral directors as needed, and to coroners or medical examiners to identify a deceased person, determine the cause of death, and perform other functions authorized by law. Cadaveric organ, eye, or tissue donation, so for organ donors. Covered entities may use or disclose protected health information to facilitate the donation and transplantation of cadaveric organs, eyes, and tissue. So there might be some medical issues you had that they need to know about before they transplant your organs into another human being. So that's what they're talking about there. Research. Research is any systematic investigation designed to develop or contribute to generalizable knowledge. The privacy rule permits a covered entity to use and disclose protected health information for research purposes without an individual's authorization, provided the covered entity obtains either documentation that an alteration or waiver of the individual's authorization for use, or disclosure of protected health information about them for research purposes has been approved by the Institutional Review Board or Privacy Board. Representations from the researcher that use or disclose of the protected health information is solely to prepare a research protocol or for similar purpose preparatory to research, that the researcher will not remove any protected health information from the covered entity, and that the protected health information for which access is sought is necessary for the research, or representations from the researcher that the use or disclosure sought is solely for research or on the protected health information of descendants, that the protected health information sought is necessary for the research, and at the request of the covered entity, documentation of the death of the individuals about whom information is sought. So this is like we've gone out the pasture type of situation here. A covered entity may also disclose, without an individual's authorization, a limited data set of protected health information for research purposes. And of course, we're going to be digging into all of those, but first I did want to go ahead and get to the overview. We got a little bit more to go before we close out. Serious threat to health or safety. Covered entities may disclose protected health information that they believe is necessary to prevent or lessen a serious and imminent threat to a person or the public. When such disclosure is made to someone they believe can prevent or lessen the threat, including the target of the threat. Covered entities may also disclose to law enforcement if the information is needed to identify or apprehend an escapee or violent criminal. Essential government functions. As authorization is not required to use or disclose protected health information for certain essential government functions. So, authorization regards to things like if you get food stamps, for example, or Medicaid, or you're on Social Security, that sort of thing. Such functions include assuring proper execution of a military mission. Oh, this is something different. Sorry, folks. Conducting intelligence and national security activities that are authorized by law, providing protective services to the President, making medical suitability determinations for the U.S. State Department employees, protecting health and safety of inmates or employees in a correctional institution, and determining eligibility for or conducting enrollment in certain government benefit programs. I do know that if you volunteer to go into the Army, the Marines, what have you, that they do have you do an extensive overall physical and checkup before they allow you in so that they can make sure that you have the type of health that they will be able to rely on, that you're going to be healthy when you're out there in the field. That's kind of some of the things that they're talking about there. Workers' compensation. Covered entities may disclose protected health information as authorized by and to comply with workers' compensation laws and other similar programs providing benefits for work-related injuries or illnesses. Limited data set. A limited data set is protected health information from which certain direct identifiers of individuals and their relatives, household members, and employers have been removed. 43A. A limited data set may be used and disclosed for research, healthcare operations, and public health purposes, provided the recipient enters into a data use agreement promising specified safeguards for the protected health information within the limited data set. So these are the instances in which possibly HIPAA would not apply, is what they're pretty much saying here. Now, there's a little bit more to it, and again, as we go deeper into the subject of HIPAA, we're definitely going to be covering it. But this gives you a pretty good idea. Like, if there's anything going on in regards to law enforcement, if there's something going on in regards to military, if this has to do with a court order or workers' compensation, that is the sort of allowances that they're talking about, where they may not necessarily have to have your written approval in the way that you might need it in some other ways. Now, that being said, what is our protection from HIPAA then? Because the RFK Jr. is claiming that it's just for research, but we don't trust him. That means we eyeball him, kids. We eyeball him. We don't let that man make a single move. A single move inside his office as head of HHS that we don't know about it. In regards to the so-called research program he's carrying on to tell us what causes autism in September. Please goddamn spare me. Maybe it's the frogs. No, we all know he's going to say the vaccines. That's what they always say because they have no idea what they're talking about. The fact that yeah, you all get what I'm saying, right? We watch him like a hawk because if it looks like he is violating one of the rules in regards to how he's using protected health information within the scope of that research, or if that research is being conducted fraudulently in some way, we can make sure to then exact our HIPAA rights. Because, yes, right now he doesn't need our permission. If we find out that he's not meeting all the protocols that are acceptable in regards to research, then we can nail him with HIPAA. And again, part of this series is I'm going to be showing you all how you would be filling out a HIPAA complaint. So again, stay tuned. And on that note, folks, we're going to go ahead and close out for tonight. We don't get very many views on this channel. The few we do tend to get removed from time to time. Please don't forget to hit the like button, hit subscribe, don't forget to hit the comments, and double check to make sure that you are still set up to receive notifications. We're going to be continuing on with this series as well as the one on advanced directives. We're going to do Down the Rabbit Hole tomorrow, and on Saturday, of course, we're going to be covering Medicaid, and I don't want you guys to miss anything. I do appreciate your time, folks, and as always, we here at Spilling Tea do hope you have a good one. I will see you all tomorrow for Down the Rabbit Hole. Bye bye, everyone.